But with that being said, let's get this presentation started.
Awesome. All right. Hello, everyone. My name is Kerstin Henze, and I'm one of the attorneys with the law firm of Kaye Bender Rembaum. I actually manage the West Coast office for the firm, which is located in Tampa. So for those of you who are on the West Coast of Florida, I would be the closest to you physically. We do have other locations. Our main office is in South Florida in Pompano Beach, Florida. And then we also have office locations in Palm Beach Gardens and the Orlando area. We are an exclusive community association law firm, so that means that we represent exclusively condominium, homeowners, and cooperative associations. I personally have been with the firm since 2010, and I've been practicing law a little bit over 17 years. So I guess you can say most of my practice has been in this area of the law. All right. So today we're going to talk about updating the governing documents. I'm going to share my slides here. All right. Let's see. Here we go. All right. So jumping into the present, updating the governing documents and why it's so important. Well, first, let's talk about the hierarchy of your governing documents. What does it mean, governing documents? So what I'm referring to when I say governing documents are primarily three documents, and that's going to be your declaration of condominium or declaration of covenants, depending if you're within a condominium association or an HOA governed under Chapter 720. And then you'll also have the articles of incorporation and bylaws. Okay. Now you might also have rules and regulations or architectural standards, specifications. Those are not typically considered part of your governing documents. They are what they are, rules and regulations. So within this framework, your declaration is going to be your supreme document, right? It is your contract between the association and the owners that purchase units or lots within your community. It is the document that's going to contain your use restrictions, right? So what you cannot do. Can you have pets? Are purchasers or tenants required to go through a background check, so forth and so on. And then your articles of incorporation and your bylaws are the two documents that essentially set out the corporate structure of your association. As you may be aware, your association is a corporation. It's not for profit, but it is an entity, right? And so when the developer first created your association, the developer needed to have filed articles of incorporation with the Division of Corporation in Tallahassee. And that is a document that essentially addresses, who qualifies as members of the association, who qualifies as a director, how many directors must sit on the board. And then the bylaws are almost an extension of your articles of incorporation. So they have a little bit more of the meat and potatoes of your corporate structure, including, how to run your elections, what happens in the event of a resignation, so forth and so on. So those documents are your governing document. Now let's talk briefly about what is the amendment process when you're looking to amend any one of these documents. And then we're going to talk about specific provisions that you might want to be looking at to see if it's affecting the way you operate or is costing money to the association, and then consider having a discussion with your legal counsel about amending these provisions. Okay, so first, the amendment process. So the amendment process will typically start with you identifying a specific section or article in one of the governing documents that you're looking to amend. And once you've identified that, typically you'll have to type up that section or article And then both 718 and 720 provide or require that when you amend a document, you have to designate what those changes are. And you have to do that with underlines and strike throughs. So any language that you're adding into the amendment, you're going to have to underline, and anything that you're removing has to include a strike through. Now, the statute does provide an alternative to this, because there might be so many changes that it might affect the ability of the owners to read and understand what you're trying to do. And so if the changes are substantive enough, both statutes allow you to, instead of underlining and striking through your redactions, you can just make your changes, type them up, but you'll need to add words at the top to the effect of, this is a substantial rewarding. Please review the original language in the original text. Okay. All right. So once you've typed up your amendment, you're gonna have to very likely present the amendment to the owners for approval. Very rarely have I seen governing documents that do not require membership approval. Okay. So if you do require membership approval, you're going to have to provide a copy of the amendment to the owners for their formal approval. And this can be done in two ways. Either you can present the amendment to the owners for approval at a meeting, or provided that your documents allow this, you might have the ability to have owners approve this amendment by the written consent process in lieu of a meeting. And I'll explain both briefly. Meeting is what you're all typically familiar with, right? A membership meeting, that's a meeting at which owners vote at, right? And so any meeting would require you to provide a notice, right, with a date, time, and location. And then typically you will mail out the notice with a copy of the proposed amendment, and then a proposed a limited proxy for owners to vote if they're not going to be attending the meeting. That's your traditional way. Now, if your governing documents for condominiums allow you to present this amendment by the written consent process in lieu of a meeting, and by the way, for HOAs, you don't necessarily have to have express language. As long as your bylaws do not prohibit you from obtaining consent through this written consent process, you can do it this way. So with the written consent process, rather than mailing a notice of a meeting, you're going to be sending out essentially, some kind of cover letter or memorandum, letting the owners know what you're trying to do, what kind of amendment you're trying to propose. Perhaps you'll outline the reasons for proposing this amendment. And then at the bottom of that form, you're going to have essentially a blank space for owners who consent to the proposal to sign the consent form, and then return the executed consent to the association. So essentially what you're looking to collect is these written consent forms, and it basically acts like a limited proxy, right? So owners don't have to attend any meeting. They simply will sign this consent form in the comfort of their homes and return it to the association. Obviously, only if the owner's in favor of the consent form, only if the owner is in favor of the proposed amendment will they need to submit the executed consent forms. Now, from the first executed consent form, you'll have 90 days to obtain the necessary approvals. Okay, so the time starts ticking from the first executed consent form. Once you receive the consent form, essentially you can go ahead and record the amendment in the public records. So that's the written consent process. Now, proxy voting goes in hand with your meeting, right? So like I mentioned, when you send out the notice of the meeting, you will likely include a proposed limited proxy for owners to cast their vote by proxy if they're not attending the meeting in person. Now, those limited proxies, they're good for 90 days from the date of the original meeting. So what that means is, let's say you have your first meeting August 1st, right? and you've counted, the ballots, you've counted your limited proxies, and you still don't have the necessary votes that you need to pass the amendment. Well, because the proxy is good for 90 days from the date of that original August 1st meeting, you have the option to recess and reconvene that membership meeting as many times as necessary up to that 90th day. There is a process to do that, and I encourage you to get together with your legal counsels to go over the specifics of how to recess and reconvene that membership meeting. Now, once you come to your last meeting on that 90th day, if you still did not get the necessary proxy votes on that amendment, essentially the issue dies, right? You adjourn the meeting, the amendment doesn't get passed, and you'll essentially have to reintroduce that amendment to the membership, a second time around. Now, distribution to the members, that refers to the means by which you get the copy of the proposed amendment to the owners for approval. So whether you're doing it by meeting or written consent process, you would distribute the amendment either by mail, by hand delivery, or electronic transmission. That means you can electronically email the amendment and either the notice or the written consent form to the owners if those owners have consented to receiving notices by email, right? So you need to have that written consent from the owners in order to be able to send them official association notices electronically. Now, vote tally refers to the percentage of votes that you will need in order to get that amendment approved. So, unless your documents provide a specific percentage, okay, if they don't provide a specific percentage, then both HOA and condominium statutes say that you need to obtain a vote of 2/3 of the membership, okay? What you'd have to do is essentially you'd have to look at the specific document that you're looking to amend to see what is the specific approval requirement for that document. So if you're looking to amend your declaration, you got to look at your declaration to see what percentage approval is required there. Similarly, if you're looking to pass an amendment to the bylaws, you got to look in the bylaws, okay? And if the document is silent, then you'll need the approval of 2/3 of the membership. You'll also want to consider, for example, is the percentage that you currently require to pass an amendment too high? For example, if you have a governing document that requires the approval of 75% of the membership, for many communities, that is significantly high. And so what you'd want to consider first is maybe proposing an amendment that would reduce that voting percentage before you present a substantive amendment to the membership. So if that amendment passes, you're recorded in the public records, and then consider providing the owners with that substantive change, right? Because now that substantive change will require the vote of the lower threshold. All right, material amendments. So there are certain type of amendments that would require 100% approval, not only from the owners, but also of mortgagees. So those lenders that have provided a mortgage on units. And those amendments typically refer to amendments that would seek to change the percentage by which owners own common elements in the condominium, or the percentage of assessments by which owners are required to pay. Okay, obviously, they're considered material, and you can see why, in order to amend any of these provisions, that would require a vote of 100% of the owners and their mortgagees. So very difficult to get these types of amendments passed. Another thing that I want to point out is amendments concerning leasing. So if you're looking to amend your declaration to prohibit leasing or limit the number of rentals at your condominium or the term of the lease or how often an owner can lease, the condominium statute provides that any amendment that either prohibits or affects leasing would only be effective against owners who either vote in favor of the amendment or that take title to a unit after the effective date of the amendment. Now, in 2021, Chapter 7 of the Florida statute was similarly amended to provide a similar type of restriction on leasing amendment. So, since 2021, HOAs governed under Chapter 720 are subject to similar restrictions. So if you're looking to amend your HOA documents to prohibit leasing or limit the terms of leasing or somehow affect leasing, those types of amendments would only be effective against owners who vote in favor and then those who take title after the effective date of the amendment. Now, whether or not those specific restrictions in the statute apply to your community, we'll talk about it. In a minute. That has to do with Kaufman language and the Kaufman analysis. Okay, so we'll talk about that momentarily. But I want you to at least be aware of what the statute says on leasing and how this might affect enforcement of these amendments once they are approved and get recorded in the public records. All right, suspension of voting rights. So both condominium and HOA statutes provide authority for association to suspend voting rights of owners if they are delinquent on monetary obligations to the association. And that includes not only regular special assessments, but also delinquent on any interest or late fees or even fines. So under both statutes, if an owner is more than 90 days delinquent, the association is allowed to suspend voting rights. Now, why suspension of voting rights? Why am I even discussing suspension of voting rights? Well, if the board properly suspends voting rights, what that means is that the unit whose voting rights were suspended, they would not be counted towards the quorum requirement and would also not be counted towards the percentage of votes that you need to get on the amendment. So for example, if you have a condominium or HOA community with 100 parcels or 100 units, and you have properly suspended the voting rights of 10 owners, okay? And let's say for your community, quorum consists of 30% of all the owners. Well, in order to achieve quorum in this case, you would need to get you will need to get the presence in person or by proxy of 30% of the 90 owners, not 30% of the 100 owners. Okay. And similarly, if you're looking to pass an amendment that requires the approval of, let's say, the majority of all the owners, well, if you've suspended properly the voting rights of 10 owners, you'd need the approval of a majority of the 90, not a majority of 100. And so you can see how for many associations, this could be a useful tool to get amendments passed. And then lastly, I just want to point out to you mortgagee approval. Your documents might have a provision, and especially if you have some of the older documents, you might have a provision that requires you to obtain mortgagee approval on any amendment that affects either the rights or priorities of mortgagees. Okay. And if you do have that requirement, there is a statutory process both under 720 and 718 by which you need to obtain mortgagee approval. It's not, it's not an impossible task, but there are a few steps that need to be followed. And essentially, you would be obtaining mortgagee approval through what is known as negative consent process. So essentially, you would be notifying mortgagees of this proposal, of this amendment. And if you do not hear back from the mortgagee within 60 days, then their consent is presumed. Okay. Now, if you do not get mortgagees involved, a little caveat, that could potentially subject that amendment to a legal challenge if that mortgagee was to later challenge that amendment, right? So only that mortgagee would have standing to challenge the amendment on that basis. Okay. All right, so that is essentially the amendment process. One other thing I want to point out, essentially under Florida law, you have a 5-year statute of limitations to challenge a recorded amendment. Okay? All right. So let's talk about now certain types of provisions that you wanna take a look to see if you either contain these provisions or if you don't, and consider the possibility of amending. So let's go through the first one. A foreclosing lender is required to pay 1% of the original mortgage debt or 12 months of delinquent assessment. So is that true or false? Okay, well, it's true in the sense that this is what both Chapter 718 and 720 currently provide, and it's referred to as the safe harbor amount, right? So this is the minimum amount that a foreclosing lender has to pay if the lender forecloses. However, your governing documents may contain language providing mortgagees with greater protection than afforded by statute. So, typical mortgagee protection clause relieves mortgagees from owning anything to the association if it acquires title as a result of a foreclosure or deed in lieu. So, look at your governing documents, and typically, this is something you would look for in the assessment section of your declaration. See if there is language in the declaration that basically says that if a mortgagee forecloses and takes title to the property as a result of the foreclosure or deed in lieu, that mortgagee will owe nothing to the association. And if you have that provision, even though the statute says that this is the minimum amount the lender will be responsible for paying, these lenders have been very savvy, okay, and they have made arguments in court, and the courts have upheld these arguments, essentially saying that because of these provisions in the declarations, these lenders owe nothing to the associations, okay? So then, yes, you'd want to consider amending these provisions by removing them, right? So a big strike through across the language of this particular section in your declaration. Now, remember, I mentioned a slide in the previous slide that if you have language in your declaration that requires mortgagee consent for certain types of amendments, then you might have to obtain mortgagee consent. Well, this is one of these types of amendments that you might have to get the mortgagee's consent. Okay. Ultimately, it's a business decision whether you want to involve mortgagees in this approval process or not. Obviously, just be aware that if you don't get their involvement and any mortgagee later raises a potential legal challenge, that could defeat the enforcement of that amendment against that particular mortgagee only. Okay, and the lender will have 5 years to challenge the amendment. All right, let's talk about another type of provision you might be looking to amend. All new owners must go through the screening process in your community. Is that true or false? Well, in order for you to be able to approve or disapprove buyers in your community, you have to have specific authority in your declaration. So you have to look and see, do your documents currently allow you to approve or disapprove purchasers? Okay. And it's not enough to just have a policy. It's not enough to just have an application process for new buyers. You have to have express language in your declaration. So if you don't currently have that language and you want to be able to screen buyers, then you might want to consider adding that authority. Well, this also not only applies to owners, but what about tenants? Do you currently have the ability to, screen tenants? Or what about other types of occupants? What about other types of conveyances? I mean, I mentioned sales and I mentioned leases, but what about, gift conveyances such as, current owner adds, a family member onto the deed, right? Do you want to be able to screen these additional applicants or these additional owners? That's something that you're going to have to review your documents, see if you currently have that authority, and if not, you might want to consider amending. Now, if you do have authority in your current declaration to approve or disapprove owners and tenants, then you might also want to be lookout for other provisions. For example, you might have a mortgagee protection clause so that while you can't approve or disapprove a mortgagee that takes title through foreclosure, if that mortgagee later decides to sell or rent the unit, some documents exempt those transactions from the approval process. Well, do you want to be able to screen a buyer or tenant from that mortgagee? Well, if so, you might have to look to amend your declaration. Your documents might also, for example, exempt certain types of parties from the approval process, whether it's spouses or children or parents. So if an existing owner, conveys title to, either a child or a parent, that transaction would not be subject to the approval process. Again, if you want to be able to screen these individuals, you're gonna have to amend your declaration. Similarly, on the topic, if you end up amending to authorize the association to approve or disapprove buyers and tenants, then you might also want to consider giving yourself authority to charge for screening of these applications, right? The statute for 718 authorized associations to charge an application fee up to $150, right, to cover the process of doing the background check, as well as authorize associations to charge a security deposit in connection with a lease to cover any damage to common elements or association property that's caused by the tenant, but only if your documents provide, right? So you might want to consider amending your documents to give you the authority to charge those application fees and security deposit. All right, let's move on to another consideration. So once the law changes, the change is automatically applicable to your community. Is that true or false? Well, it's false, right? I get this question all the time. Which one trumps over the other? Does Florida statute automatically trump over the provisions that you have in your declaration? And the answer is unfortunately, well, it depends, right? I know board members don't like to hear that, but it really does depend. And it depends on whether or not you have what is known as Kaufman language in your declaration. And Kaufman refers to these magical words as amended from time to time that you'll typically find referenced after either Chapter 718 or reference to Chapter 720 in your declaration. So if you open up your declaration, typically within the first couple of pages, you might have a statement that says, this association or condominium or communities governed under Chapter 718 or 720, and then it might say, as amended from time to time. So if it has that language, what that means is that substantive changes to Florida statute will apply automatically to your community retroactively. So remember I talked about that leasing provision in both 718 and 720. So for condominiums, that provision went into effect 2004. For HOAs, that went into effect in 2021. So if you have Kaufman language in your declaration, that means that that provision, that lease restriction in the statute will apply to your community. So once you pass your lease amendment, you would only be able to enforce it against those owners who voted in favor and those who take title after the effective date of the amendment. Okay. Now let's, for example, let's take a scenario where your declaration does not have Kaufman language. Well, if you do not have Kaufman language, then the constitutional argument or position that you can take is that these these changes to the statute, the leasing restrictions in this particular case, do not apply to your community. What applies to your community was the law that was in effect when your declaration was recorded. Okay. And if, for example, you have some of the older documents, I'm pretty certain that when your declaration was recorded, these lease restrictions were not in effect under Florida statute. And so essentially, if you get these lease amendments passed, you could take the position that these lease restrictions would then apply to everybody in your community, not just those who voted in favor or those who take title after the effective date of the amendment. And the reason that you can, present that position or that argument is because there's a basic principle in the law that the legislature can't just come in and make laws that impair existing contractual rights of parties. And remember, I mentioned that your declaration is a contract between the association and the owners that purchase in your community, right? It's a document that contains your terms and conditions of living in your community, right? And so if you want to restrict, if you don't want to abide by, certain leasing requirements, then you just don't buy in that community, right? And so that's the premise behind this. So whether or not, I guess the big takeaway is whether or not you want to have Kaufman language in your documents, or whether or not you have it and you want to remove it, that's that's something that I encourage you to discuss with your legal counsel. It is a bit of a complicated topic, and so you want to discuss with your legal counsel the benefits, right, or the drawbacks of having Kaufman language in your declaration. And if you have it, perhaps you might want to consider removing it. Okay. All right, we have just a few more slides. All right, the next one. The board must obtain a vote of the owners before making a material alteration. Is that true or false? Well, material alteration is a concept, for condominiums. And what Chapter 718 of the Florida statute currently provides is that unless your declaration provides otherwise, okay, material alterations have to be approved by at least 75% of the membership. So that means is that you have to take a look at what your current declaration provides. If it is silent on material alterations, then the default percentage that would apply to your community is 75%. If you don't want to have to go through the process of getting the approval of 75% of the membership, because that seems to be extremely cumbersome, then you might want to consider amending, and especially if you're looking to do a material alteration project in the future, you might want to consider amending the declaration to either include a provision for a lower membership approval, or modify the current membership approval and lower the threshold to something a little bit more manageable, such as a majority of the membership. You might also want to consider a provision that includes a dollar amount threshold. So for example, the board can spend up to, X amount, typically, either a percentage of the budget, let's say 10% of the annual budget on, material alterations or improvements, but then anything beyond that threshold would require membership approval. So you can definitely draft your amendment to read that way. Now, for HOAs, material alteration is not really a topic that is addressed in the statute. And so really, this is going to be very document specific to your community. And typically what you'll see with HOAs is you're more likely to have a restriction on spending. So you might have a provision that limits the ability of the board to spend, up to a certain amount of money, and then anything beyond that threshold, you might have to get membership approval. And so if you are looking to undertake some capital improvement or material alteration in your community, then you might want to take a look at your documents to see what they currently provide, and then possibly amend if necessary. Now, what I've just described or talked about is material alterations, right? This is very different from necessary maintenance obligations of the association, right? So if we're talking about, undertaking a repair that is part of your necessary obligation, typically there is no dollar threshold limitation on that. Now, sometimes, whether or not a, necessary maintenance or repair is considered a material alteration, that can be a little bit blurry. So I do encourage you to speak with your legal counsel about, whether or not a specific repair or maintenance obligation is in fact considered a material alteration. All right, here's another one. Delinquent assessments accrue interest at the rate of 18% and a $25 late fee applies. Is that true or false? Well, it's true in the sense that both the condominium and the HOA statute provide these thresholds, right? False in the sense that your specific documents have to actually authorize you to charge these interest and late fees. Okay, so with late fees, the authority to charge late fees for condominiums and HOAs have to be either in your declaration or in your bylaws. And then assuming you have express authority to charge late fees in your documents, then you can charge the greater of $25 or 5% of the delinquent assessment. If you don't currently have the authority to charge late fees, then any attempt to collect late fees obviously could be subject to a successful legal challenge. So you might want to look to amend to give you that specific authority. With interest can be charged at the rate provided in your declaration. So, for example, in some of the older declarations, you might have the authority to charge interest maybe up to 10% or up to 15%. Well, if that's what your governing documents currently provide, then that is the rate that you have to go with. You won't be able to charge the higher rate that's currently provided in the statute. So you might want to consider amending. If your declaration, your bylaws are silent on the interest that you can collect, then provided that it still gives you the authority, then you can charge up to the highest rate currently provided, which is 18%. So as a practical tip, when you're looking to amend your documents with regard to the ability to charge interest or late fees, what we would recommend is rather than including a specific sum, that you simply just have the amendment give you the authority to charge interest or late fee up to the maximum amount allowed by law. This way, should the statute change in the future and these fees and interests are increased, then obviously your documents will just adapt to the higher percentage without having to amend your documents. All right, another consideration that you might want to take a look at in your governing documents and possibly amend. If a pipe in a wall only provides services to one unit, that unit owner is responsible for the maintenance. Is that true or false? Well, it depends, right? So maintenance obligations are typically set out in your declaration, right? But just because a particular pipe or a particular utility only services one unit, that doesn't mean that that owner is responsible for the maintenance, repair, replacement of that pipe or utility, right? It depends on how your documents are written. Perhaps your documents actually say that even if the pipe only serves a particular unit, if it's actually located in the common elements, then it's the responsibility of the association rather than the owner. And so if you haven't looked at your maintenance of the maintenance section in your declaration, take a look and just see if the current maintenance obligations of the association and the owners, reflect really how you currently operate. And perhaps it does not. Or, do you want to shift maintenance responsibilities from one party to the other one? If so, then this is something that would require an amendment. I also want to point a few other things. Incidental damage, and this will apply particularly with condominiums, and it could apply with HOAs if you have, for example, townhome style units. So incidental damage refers to, um, let's say the association has to go in and repair a pipe that is, it's a common element pipe. And in order to get to the pipe, the association has to go through the backsplash of your kitchen counter, right? Or has to go through the cabinets. Okay. Well, if you have an incidental damage clause in your declaration, that means if the association has to remove that backsplash or has to remove the cabinets to get to that common element pipe, the association is going to be on the hook for any damages to that particular property. Okay, so it's a provision that could potentially subject the association to significant cost. And so you might want to consider removing that provision. Another thing that you want to also be on the lookout with regard to maintenance is do you have a self-help remedy provision in your documents? So self-help refers to the um, to the option for the association to essentially go onto the unit or the parcel and then undertake the maintenance responsibility of the individual owner and then charge the owner for the cost. Right. So, for example, if an owner fails to mow their lawn and their grass is, 3 feet high, the association, if you have self-help remedy in your declaration, the association might be able to go onto the property, mow the lawn, and then charge the owner for the cost of mowing. Well, case law has come out that essentially state that if you have self-help remedy, you're going to have to at least try to exercise it, right? Before you can pursue other legal remedies, right? Before you can either go through a mediation process or file a legal action in court to force the owner to comply with their maintenance obligation. Now, self-help remedy is a tricky one, right? It's not always recommended. It should be exercised really on a case-by-case basis. Because it has the potential of exposing the association to liability, right? Whether it's, for damages, or it might expose the board member or the association representative who goes onto the unit or the lot to a hostile owner, right? And so you don't want to get in that confrontational situation. So self-help remedy is not always recommended, right? The alternative is to pursue formal legal action to get essentially a court order forcing the owner to comply with their responsibilities, right? But unfortunately, if you have self-help remedy, courts have now said that you have to at least try. You got to at least show up at the owner's house with the contractor and try to mow the lawn and have the owner basically kick you out before you can pursue that legal remedy in court. And so the takeaway here is have a discussion with your legal counsel whether or not you want to have self-help remedy. And if you currently have that provision in your declaration, you might want to consider amending it. All right, and I think this is it. So what have we learned today in summary? Well, we've learned that safe harbor mortgagee liability may be limited by old language in the documents. You might be losing money from interest and late fees. New laws may or may not apply to your association, depending on whether you have Kaufman language in the governing document. And old language in documents could also potentially expose the association to discrimination claims. And now for a fun slide, healthcare alert, owning a home in an HOA may be hazardous to your health. All right, and that's it. That's all I have for today. I'll stop sharing now, but I'll stay a little longer to go through some of your questions and hopefully answer them.
Sounds good. Kirsten, when there's about Marielle's back as well, there's just a handful of questions on there. And while you're looking through those, ladies, I'm going to quickly mention that the evaluation link is now in the chat. If you're just hitting chat for the first time, you're not going to see it. You must have pressed it earlier. So go ahead and press the chat button now. if you haven't already done so. And once Kirsten and Marielle get one question in, I'll place the link into the chat again so everybody can see it. After you click the link and fill out your evaluation, you'll hit submit. The confirmation screen has Kirsten's contact information as well as ACE's class for next week and ACE's website, as well as a link to download and save the slides that Kirsten used today. Also, a recording of this session will be on both the acebytsk.com website and also on kbrlegal.com. So again, press the chat button now if you haven't already done so. Back to you both for a little bit of Q&A with the a little bit of time we have left.
Awesome. All right. So let's start at the top with Ron. Our HOA has made one amendment in 19 years. Is it permissible to make several amendments at one time, even though it might be legally costly?
I mean, there's no set limit of the amount of amendments that you can present to the owners for approval. I can tell you from experience, depending on the community, some owners do get overwhelmed when you give them too much, right? And so for some communities, it might just be not only more cost effective, but beneficial to just present, a handful, amendments at a time. And then you also want to consider how you want to present those amendments in terms of, do you want to present each amendment as a separate proposal? So each amendment gets its own yes or no vote, or do you want to present the amendments like the legislature does, right? It's an all or nothing vote. So here are 5 amendments, and you got to vote yes or no for all 5, right? So there's benefits and drawbacks to do it either way, so just something to consider.
Excellent. Anthony, does a rental tenant qualify for a voting right, or is that right specifically reserved to the deed-bearing owner?
So if we're talking about who gets the right to vote, it typically is the record title owner. Tenants do not typically have voting rights. Now, if you are in a community that have documents that specifically say, for example, if your unit is owned by multiple owners or by an entity, you have to designate specifically who can vote that unit. Unless there is a restriction of the voting member being an actual owner, I mean, you could conceivably designate a non-owner voting member. So it depends on your documents, basically.
Thank you. Next up, Lorraine, can you confirm that authority to charge late fees must be both in bylaw and declaration, or only one of those?
So it's one or the other. So if I misspoke, I apologize, but yes, it typically would be in the declaration or bylaws, not both.
Perfect. Fran, in an HOA, can the board decide on material alterations if the docs don't provide specific limitations, yet gives implied powers if the docs are silent on a specific power?
So with HOAs, unless your documents specifically, require membership approval for a specific type of material alteration or capital improvement, or impose a certain dollar threshold, essentially, as long as the particular improvement or alteration is a bona fide association expense, you can undertake it without membership approval. So it's very document specific with HOAs.
Okay, Sandra, our docs say we charge 18% and a late fee, but does not say what the late fee amount. How do we determine the late fee? Okay,
So 18% would obviously be for interest. The late fee would be, the maximum amount provided in the statute. So it would be $25 or 5% of the delinquent assessment. I would have to really review the language of your declaration to really see, what it actually says about late fees.
Okay. Bruce, do you consider incidental fare to the owner whose property is damaged?
Well, it's not really a legal question, right? It's a fairness question, so I'll just decline to answer it for the time being.
Okay. Uh, Melissa, the HOA I work with wants to pass new rules. How do we notice the owners? And do we have to mail them out or can we post on the website? I think she means how do we notify the owners and do we have to mail them out or can we post on the website?
Right. So with rules, both statute actually say that if you're going to amend rules concerning the use of the property, then you have to give owners at least 14-day notice of the meeting in which you're going to adopt those rules. There's no specific requirement to provide them with a copy of the proposed rules, but you have to give them at least 14-day notice of the meeting, which notice can be mailed, hand delivered, or obviously emailed to owners who have consented to receiving notices by email. If you're going to adopt rules concerning just use of the common elements or common areas or facilities, that just requires a 48-hour posted notice.
Okay. Barbara, our documents have not been updated in 40 years. Where should I start to update them?
Where you start from the top. So typically, I'm happy if you want to reach out, Barbara, I'm happy to discuss sort of the process that we've done in the past and which, I found to be the most successful when we're talking about overhauling 40-year-old documents. But typically, you know, I recommend, and what I usually do is I literally start with reading every single one of your documents, and then I prepare a comprehensive letter with all my recommendations and suggested changes, right? And then, I typically discuss it with the board, and then the board decides what changes. And typically they say, yes, we want to do it all, and then we go into the drafting stage. So um, that's what I typically recommend.
Perfect forum for this question. Thanks, Barbara. Uh, Alvaro, can rules and regulations be changed by board of directors?
So typically, amending rules is a function of the board. However, I have seen documents, especially some of the older ones, that do sometimes require membership approval. And so you really want to take a look at your documents to see, if they require membership approval on rule changes.
Ellen, may we use electronic voting for written consent?
So if you have instituted electronic voting, um, if you have instituted electronic voting, then, the benefit of electronic voting, I mean, it essentially acts like a written consent, right? You don't even have to be physically present at the meeting because the e-vote automatically counts as quorum. Okay. So that's the benefit of e-voting. So if you haven't instituted, then definitely encourage you to do that.
Awesome. Michael, what is the time frame to amend documents?
Well, if we're talking about a comprehensive overhaul of the documents, I mean, it's not a quick turnaround. I mean, it could take 6 to 8 weeks for me to review, your declaration, your articles, your bylaws, and then all amendments. And obviously, that's going to depend on how many amendments. So, and then there's a drafting stage. So it could take several months just for the attorney to do their work, but then obviously you got to consider, the board has to meet, the board has to review, right? And that could take as quickly as the board wants to do this, right?
Okay, Blaine, if the board has the right to approve ARC guidelines, does the community have the right to chime in or vote on the guidelines as well? The guidelines is not changing anything in the documents, but obviously dumbing it down for the homeowners as well as we are adding Florida statutes.
Well, again, you'd have to look at the governing documents to confirm whether or not membership approval is needed. Typically, no. Typically, the board is the one that has the authority to approve ARC guidelines. Now, politically, it might be beneficial to, survey the community, get their feedback, but legally, you wouldn't be required to get their approval.
Hey, folks, I know
Okay.
Kirsten only has time for one or two more questions. We're at the top of the hour. I also want to quickly mention those of you, the chat module. The chat module is for questions for me, tech questions and evaluation questions. Questions relating to the class into the Q&A, please. Thank you.
Yeah, let's do
Jeff,
like
do you
two
want to
more.
maybe pick one or two that you think are kind of most relevant, most up Kirsten's alley? Because we have a
Let's
bunch
see.
here still. All right, let's see. We'll just go in order. Is it possible to work with council to update wording and eliminate Kaufman language?
I mean, yes, it is possible. I would just, if you have Kaufman language and you're looking to reduce, then have your legal counsel give you guidance as to, which Florida statute or the year of the Florida statute that would apply to your community, whether it's, the date that you added Kaufman language, if that's something that you had added by amendment, or is it the law that was in effect at the time of the original declaration? So you want to have that discussion with counsel on Kaufman.
Kind of a similar question about this Kaufman language. Owners purchased for more than 10 years ago, rental restrictions were set up. Owner voted no. Does the restriction, although apply, could the board set waiver in any way?
Well, again, it depends whether or not you have Kaufman, right? If you have Kaufman, obviously that restriction, the statute would apply. If the owner voted no, then you're gonna have difficulty in enforcing that lease amendment against that particular owner, right? Because that owner can then use as a defense, hey, statute applies, I voted no, so technically you can't enforce this lease restriction against me. If you don't have Kaufman, obviously you can take the more aggressive approach. Okay.
Bernard, in a homeowner association in which a special membership meeting has been called by petition of residents, is a quorum met by counting residents on Zoom or only those in person by proxy?
Okay, so a little bit off topic, but quorum can only be established by those who are physically present or those who have submitted a limited proxy. So while the owner can attend the meeting by Zoom, that Zoom attendance in and of itself would not be counted towards quorum technically. So they needed to have submitted a limited proxy in advance if they're not going to be physically present at the meeting. All right.
Okay.
All right, I snatched the Q&A
Thank
away.
you
Now
so
Kirsten has
much.
appointments to go.
Or we could be sitting here for hours.
We could,
Yeah.
and I know you guys have a lot of great questions, so I encourage you to reach out directly and ask those questions. We appreciate how much you've engaged and we appreciate all the information. We hope to see you guys next week. Make sure to fill out the evaluation form that Jeff has placed into the chat a few times now. If you do have any questions, you can reach out directly to us. Jeff, anything to close us out?
No, that's wonderful, Kirsten. Thank you. I'm going to hang out and go over the evaluation process more slowly with everybody. But Kirsten, any parting words before we let you get to your appointments?
Yes, thank you so much for having me. This was fun. I hope to do it again. And again, feel free to reach out. The main number of the office is 954-928-0680. That's our main number, and it connects all of our offices. So, and encourage you to go on our website as well.
Thank you. Thank you. And yes, Kirsten is
Thank you so
located on our
Thank
West
you.
Coast office over in the Tampa Bay area. So give her a shout if we can help and if KBR can help in any way. Sorry for my stuttering and mumbling. My dog is making a lot of noises behind me and throwing me off here. All right, ladies, thank you both. I'm going to remain on and go over the evaluation one more time.